did, and I can honestly tell you that those images still haunt us. I mean, partly from the photographs that were taken by such extraordinary, just the pathos, just what would make you mad, the criminality of it, which is that you have people running in desperation, fleeing from what they didn't even know was a poison gas. And the fact that there was now, and there was then as well at that stage, there was enough evidence to say that here was a company which knew that it was being lax about its environmental regulations, partly because there were none that it needed to follow in a country like India. So it was what happens always even now, where if your standards are low, how do you blame them? Because the American multinational was actually following much more stringent standards, much better procedures in its parent plant than it was doing in Bhopal. And there was no, we can call it, I would call it criminality. Lawyers would simply say, but the law doesn't require them to do so. But there is something more than the law, and the something more than the law simply means that it doesn't matter if you were not required to do so by law. The fact is, you should have had the same universal standards, and there was clear negligence on their part. There was clear reasons why they should have been held liable for that, for the incidents that happened. There were also things that they could not have been held responsible for. For instance, the settlements that came outside the factory. Now, this happens in all our cases, happens invariably. A factory comes up and then people start living close by. You do not have the systems for adequate warning, for adequate evacuation, and you ended up with having a disaster like Bhopal. Now, when the judgment was given, I think it was a very difficult time, and I think there will be a point at which your book will be very important whenever that history is understood, because there is going to be 2 points of view, and I think we need to understand those 2 points of view. There is going to be the point of view of the people, the activists on the ground would say, this wasn't good enough. This was not good enough because not only, I don't think money was the issue. In my view, I don't think money was the issue, as much as the fact that you basically made sure that all criminal liability was removed in the judgment as well. And it can well be argued that, yes, the money was important and you needed to make that instant compensation, and I do agree that that money was important then, and that haggling over the amount of money for years and years and years to come, you probably would have got a few billion by the end, maybe, but it would have translated to the same, because 470 million in 1989 would have been the same as, would have had a lot of value at that stage as compared to the millions and the billions that you would have got later. But I think, and that's where, in my view, I think if Justice Pathak had been alive and in the Supreme Court and not in Hague, I think he would have reopened the case. I think he would have reopened the case from 2 points of view, in my view. One, there is increasing evidence now that the number of people who were actually affected by the disaster are a lot more than what we had thought then. Because at that stage, there were issues of death, there was issues of disability, and there was injury. And there was a report that was prepared, again, not something that I believe any judge can be held accountable for. The report was prepared by government. It was actually not prepared by government, it was prepared by UCC, okay? Now, it was a secret confidential report that the government took. Government came up with a figure of how many people were therefore affected. That became the basis of the calculation. That then became the basis of the negotiations for whatever the ultimate amount was fixed. Now, it is not for the court to either say how many people were affected. It is not for the court to say what should be the compensation. It is the court to actually come up with a clear settlement to say, okay, this is what we would say. And I think therefore I would not say that it is Justice Pathak who in this case can be held responsible. I think the fact is, and I would not even say government, I mean I would say we need to have that much charity in history to say that just think of a government which was completely lost at that time, dealing with these scores of people lying on the ground, not having any idea how to deal with it. We've never dealt with compensation at the scale before. I mean, they say everybody in Bhopal got a piece of compensation. Okay? How did you actually calculate who had disability, who had injury? You know, it became, you know, we cannot even give compensation to people when they're affected in small numbers. Here was a massive disaster. And in 80s, when there wasn't even the understanding of these issues at that stage. But I think if I was to, I would argue that Justice Pathak would have reopened the case, because I think the knowledge today is, one, that the damage to people is much more than the damage that was anticipated or even, you know, computed in 1989. The reason is very clear. We didn't even know what people were affected by. We didn't even know the extent of the damage that will happen. We didn't really know what would be the long-term impacts. You know, how many more cancers would people die from? How many more disabilities would come up? Now, clearly that is an issue which, in my view, therefore, if the liability issue had not been squashed, we would have had a chance to come back to it. That would be one thing. The other is a more serious issue that we ourselves discovered, the Center for Science and Environment, the organization I work with. You know, we've been hearing for a number of years that there is concern in Bhopal that there is contamination of the groundwater there because of there is some contamination in groundwater. Now, nobody could explain what was happening. So we have a laboratory, as you know. So we actually looked at the factory, we looked at the groundwater in that area. And what we did was interesting. Everybody assumed that what was contaminating the groundwater was the cause of the accident.
The methyl isocyanate.
Exactly. We actually went back to look at what did the factory produce. So we went back to the pesticides that they were producing, the byproducts of the pesticides, what would be the contamination of hazardous waste if such a factory was operating but not destroying or not disposing of its solid waste properly. That was the question we asked. And so we went back and we were lucky enough to actually get access, which is another big issue. Why should any one of us not have access to that factory? We managed to get access to the factory. We managed to collect samples from the factory. We tested it. We also did something because we knew the matter would be very disputed. We collected half the samples ourselves and gave the other half to the Central Pollution Control Board and asked them to test it. And what came out is shocking. What came out is that that factory, even till today, has large places where there is mercury lying there. You have places where there is clearly pesticide residue lying there. This is basically persistent organic pollutants. So these are living pesticides, and they are still lying on the ground over there. There are children playing there. That water is leaching into the groundwater. That is actually creating problems for groundwater which people are drinking downstream. Now, clearly there is an issue of liability here. There is clearly an issue where the factory was doing it, and this was UCC, this was Union Carbide, and you cannot argue with me that they're not liable for it because they changed hands with Dow. So I think, that is, in my view, the most critical flaw, and I know Justice Pathak would have rewritten his judgment, would have found a clever way out of it, and said, yeah, you were liable maybe for the disaster that hit on that night. You were not liable, we've written off that liability, but we don't write off the liability of all the muck that you left behind when you fled. You've sold it off to Eveready, you've now sold it off to Dow, and everybody is pushing the buck and saying that they're not responsible. What was bizarre is what happened to us. I mean, after we tested, the Madhya Pradesh state government said that they would arrest me because I made an illegal entry into the factory. And I said I would love to be arrested because then it would be, I mean, she would come and write about it and we'd have a lot of issues to discuss it. But I said, you know, I mean, the fact is for them, don't talk about it. Don't do anything about it. And the second thing, which was even more bizarre, was that the Pollution Control Board, the Central Pollution Control Board, study was not released. So we leaked it. We got a copy and we leaked it. And then I got a notice from the government saying that you would be covered under the Official Secrets Act. So I actually, no, I didn't get a notice. The chairman of the Pollution Control Board was told by the officials saying that how dare he leak it and that he would get into trouble. So I actually wrote officially to the Secretary of Chemicals and Fertilizer or Chemicals, whatever the department is which looks after Bhopal, saying that I take full responsibility, that I stole the document and I leaked it, and that they could do what they wanted about it. Now, I think essentially the point I'm making, the only point I want to make here is that I think it is a difficult issue, the Bhopal issue. I think we need to be much more, as an activist, I would be much more kinder, much more understanding of the judgment that was made in 1989, okay? Because I think that's what the circumstances was demanded then. But I think when I look back on it, I think the major flaw, as I said, is the fact that you ended up with removing criminal liability. And that's where I would like that reinstated. So my question to you, Jay, is, now that you are a chela of Justice Pathak, you find a way of reinstating the criminal liability of UCC back in court. Okay. Thank you.
Now let the disciple take over.
Yes.
I would be grateful to his graduation from the IRS Law College in Pune. Then he went and graduated from the University of Pennsylvania Law School in 2013. He was also a foreign associate with the litigation firm Klein and Spector, about which most of you would know, who deal with law, a very, very famous firm in this field in Philadelphia. Their Philadelphia office, they have offices all over. I used to know them in New York in the 60s. And he is currently, look at the leaps and bounds that he has made. He is now working with Justice R.S. Bhopal, Judge of the Supreme Court, as his judicial law clerk. Now, of course, a person who could, with this background and at this tender age, delight us with a product like this, Aequabilis, in our hands, has a great, great future. Thank you. Yes, I have absolutely no doubt about it. I will speak about the book later. But you better answer the question that has been posed to me before I intervene.
Ambassador Mehrotra, that was a very generous introduction. Thank you, and I hope I live up to that. Dr. Narain, you've raised a lot of very interesting points. And as an activist, I do understand that a lot of these issues which have been recorded in this judgment appear too dry and too far removed from the pain that the victims suffered at Bhopal that fateful night and also for many years after that. But I think the most important point that I've tried to make in my book, particularly in the analysis on the Bhopal case, is that given the circumstances at the time when the disaster occurred, And given the limited amount of information that was available to the court, and particularly to the bench that Justice Pathak headed, in terms of the limited data, how many people had gotten injured, who suffered critical injuries, how many people had passed away. Given the paucity of that information, it was very difficult to actually arrive at a decision which would ultimately be taken as the fairest decision possible in those circumstances. But that said, I think with those constraints in mind, Justice Pathak was, in my mind, responsible for putting an end to what would have been a very, stretched out litigation. And we know how litigation in India works. It can go on for decades, if not more. A regular civil suit can take a few decades to resolve. And here were claims raised by 4,000 or 5,000 people. It would have been nearly impossible for all of those claims to have been entertained individually in court. So given those constraints, I think the most important thing that people fail to give Justice Pathak, his due for, is that he headed the judiciary. He didn't head the executive. And if not for him, India wouldn't have gotten the $500 million from Union Carbide in the record time that it got the money in. And once the money was repatriated into India, I think it was the responsibility of the government at the center and the government at the state to disperse those funds in an equitable manner, in a manner that was best suited to address the needs of all of those victims. And unfortunately, successive governments at the center and state, I don't wish to take any names, but they failed. They failed the common man in Bhopal. It still took us very many years to come up with an effective environmental code, and I'm sure Dr. Narain would agree with me that we still don't have a very strong environmental law to tackle these transgressions by multinational corporations. But at the end of the day, you'll have to pardon me. Justice Pathak for me could do no wrong, and the quantification of damages that he arrived at in the judgment, to my mind again, is the most logical, the most systematic quantification that could have been arrived at, given the limited information that was available with the court. And when you're faced with someone like Mr. Nariman on one side, who, and a lot of my colleagues from the law are here, and they know how persistent, dogged, and ruthless Mr. Nariman can be when he holds a brief for a big client. Given those circumstances, I think it's commendable that Justice Pathak rose to the occasion, brought an end to all of the litigation connected to this matter, and brought succor to the lives of those thousands of victims in Bhopal. And I think the focus ought to shift in the journalistic commentary, and I mentioned this in my book, is that a lot of our journalists who write on these issues, we have some fine journalists in India, I'd like to say that at the outset, but a lot of the other journalists that have written on this issue don't even have a basic background in the law to understand the issues that were dealt with by the court. And a failure to understand those fairly complex issues reflects in a lot of the commentary that has come out since the judgment. They attempt to apportion blame on the judges, whereas the real blame ought to have been on the executive. Why wasn't the money used effectively? Was the money not enough? The money, ladies and gentlemen, was more than enough. If it were kept in a simple interest, with simple interest in a bank, it would have yielded upwards of 100 crores a year for perpetuity. So the money was more than enough, but the use of it was more than questionable, is what my stand is in the book. But I urge you to have a look at the book, the chapter in particular on Union Carbide, and I'd love to hear about your criticisms, about your suggestions about how the bench ought to have dealt with this issue. And with that, I'd like to request Ambassador Mehrotra